I will say that I'm obviously coming at this presentation largely from a practitioner perspective. As I said, I'm 95% of the time a practitioner, only 5% of the time an academic, so that obviously informs my viewpoint a lot. And the other thing I'll say is, certainly, as is often the case in academic work, nothing I am saying is particularly new, but I do think it's timely, and I'm going to explain a little bit why the topic I'm talking about I think is extremely important right now for people who work in the area of disability and who work in the area of access to justice and who work in the area of expanding legal systems to include marginalized and disadvantaged people should be thinking about this topic right now. As most of the academic and scholarly research-oriented work I've done starts with a personal story, and that's true here too. And in this particular case, what launched me on this journey into talking about how we define disability legally for human rights purposes, which is ultimately the topic I'm going to be talking about today, started when I was sitting in a hearing with a client, watching the client listen to the employer's lawyer question whether the disability that the employer had accepted and accommodated for 10 years actually existed, and calling into question the fact that she didn't have sufficient medical evidence to prove that she in fact had a disability, in large part because the employer had accepted it and not questioned it for 10 years and had accommodated her. And now that we were at a hearing, because she was seeking accommodation that the employer wasn't willing to provide, they were raising a fundamental preliminary issue as to whether or not there was even a disability that would allow her to access the Human Rights Code to begin with. And so this story, this personal experience of mine, set me off on a bit of a quest to talk to other lawyers who work in the same area that I do in human rights and in law, in labor law specifically, to ask if they had experienced similar things recently. And the people I spoke to all said, you know, you're right, it's true. More and more often what we are seeing when we are supporting or representing applicants who are claiming human rights, access to human rights on the basis of disability, is we're more and more seeing preliminary objections to whether there is even a disability to begin with in order to access the Human Rights Code. And that's a problem. And it's a problem for a lot of reasons that I'm going to unpack today, and it's becoming more and more of a problem. I think we're on the edge of a snowball here that's just going to keep rolling if we don't start to put on the brakes. Now, it goes without saying, I think, that historically at least, disability has always been considered a medical concept more so than a social or political one. And it has been one that has been defined and debated and talked about using medical terminology, using science, using medical tests, and relying on the medical judgment of professionals. The need to categorize or to define disability largely arose out of a clinical perspective early on, and was only started to be brought into legal landscapes when the law started to want to regulate and categorize people with disabilities, largely to try and institutionalize them or to keep them out of the public. And what I have up on the slide here is an example of one of the earliest laws that tried to define disability in some way, which is one of the infamous ugly laws. In this particular case, Chicago's City Code, which, as you can see, really relies once again on medical terminology. So persons who are diseased, maimed, mutilated, deformed, before it kind of meanders off into a more of a value-based judgment, improper persons. So this is one of the earliest attempts, and it's highly medicalized and medically specific. And it also speaks to what was commonly, and is still in a lot of ways commonly, the case, which is that our ways of talking about disability and our ways about trying to regulate disability was based on a system of clinical surveillance and voyeurism almost, in some cases voyeurism literally, that reviewed, categorized, and judged disabled bodies and then sort of put them away in that container and forgot about the container somewhere. And this is all part of the broader medical model of disability, which I won't go into a lot of detail on because it's a pretty well-trod concept in the area, but which locates the source of the problem, quote unquote, of disability in the individual and in the medical condition, and not in the interaction between the medical condition and society. And certainly this experience of surveillance and voyeurism isn't one that was restricted solely to law. It's certainly not been restricted solely to how law has dealt with disabled individuals, but also with how medicine has dealt with people with disabilities. And I have an excerpt from Lisa Bloomberg's essay, Public Stripping, which speaks to that up on the slides. And that the medicalization of disability has traditionally dehumanized the person at the heart of the issue, and subjected them to levels of surveillance and control, to an exposure, to a lack of privacy is well documented, and is part and parcel of what led to things like the ugly laws being developed. The social model of disability, which is the antithesis in many ways of the medical model and one of the cornerstones of the disability movement, aim to try and push those things back and to say that the tendency to address disability strictly in medical terms, strictly through the point of view of clinicians, and strictly using medical language and medical tests was inappropriate, and failed both to recognize that there is a person at issue and also failed to recognize society's complicity in the creation of disability to begin with. And so after a while, sort of in the mid-1970s and going forward, we start to see alternative definitions of disability coming forward, definitions that are not based on the nature of the medical condition, but recognize rather that disability is different from impairment, is the interaction between impairment and social, political, economic, cultural, historical structures that cause people with disabilities to be excluded from society. And I've provided one definition of disability from the 1970s, but this is by far not the only one that existed, and for the large part, the disability movement doesn't always agree. For one thing, this only speaks to physical impairments, as an obvious example of why it would not necessarily be considered a comprehensive or fully agreeable definition of disability. But it was an improvement, at least. And in Canada, in the strictly legal context, we saw a very strong statement from the Supreme Court in the early 2000s, which endorsed the concept of the social model of disability and of moving away from biomedical definitions of disability. And that was in the Montreal City case, where the Supreme Court explicitly said, no, we don't require there necessarily to be biomedical evidence of a disability. And we're not going to bind ourselves to a strictly biomedical definition of disability. Rather, we believe it's important to look at the broader picture, the broader societal structure, to see whether or not this person, because of an impairment, is in some way being excluded from full participation in society. Fantastic. But here's the problem that my story at the beginning of this discussion forecasted. Despite this great statement from the Supreme Court in 2000, we haven't seen this actually get put into practice. And part of that is because society's tendency to want to categorize and surveil and medicalize the discussion about disability is one that dies very slowly. And the other is because there's this political and societal obsession with ensuring that people must prove that they are entitled to things in order to get access to them, even when we are talking about something as fundamental as human rights. And the social model of disability, obviously by its very nature, doesn't easily allow for it to be structured into gatekeeper tests. Who is to say who is or isn't disabled when we're talking about disability as a construction of society? How can we base a test for benefits on something that isn't about the person who is seeking those benefits, but about the broader societal structures and our own failings at large in Canada? So the reality is we just don't do that. When it comes to legal tests, and who is or isn't a person with disability from a legal perspective, we just still don't do that. We do things like what's on the screen here from the Now You See Her, Now You Don't article from Critical Disability. And dealing with specifically the Ontario Disability Support Programs legislation, which defines disability in a very restrictive way based on the medical condition you have and its impact on your daily life and your ability to perform activities of daily living. So very much centered once again in the individual and in the individual's medical condition, and one that requires the individual to provide a large amount of medical evidence to the legislative bureaucratic gatekeeper to prove that they meet this definition before they can get access to any kind of benefit. And the reality is that law and medicine sit pretty comfortably together because they're both practices, when we take strict technical black letter law, that are very much concerned with objectivity, certainty, and predictability. And it's very easy, I think, when people are writing laws and when people are constructing gatekeeper tests to just outsource the creation of a definition of disability to medicine to take care of and to sort of abdicate any responsibility as legal practitioners and as writers of law and as people who are trying to demonstrate that their clients meet definitions, to just leave it to the medical experts to try and deal with it because they're going to be better suited to deal with it than we are. But the issue is that medicalizes disability all over again. It undoes all the work that the social model was supposed to do. And right now the issue is that it's moving into human rights law and it's becoming a worse problem. Now, it's always kind of been in human rights law because the definition of disability, at least in the Ontario Human Rights Code, is based on medical conditions. And because of how we structure our human rights law, you have to prove you are a member of a group defined based on medical conditions, before you can even access human rights law. You are not protected by the code unless you meet this definition. And so the very act of trying to access human rights law is more and more an act of public stripping. The Supreme Court has actually recognized this last year. They were talking here in the context of tort law more so than in the context of human rights law, but they recognized that courts, when dealing with the concept of mental injury, were talking about clinically diagnosed by an expert, recognizable psychiatric illness. They were looking for a DSM criteria and evidence, medical evidence from an expert that you met that DSM criteria before they would even recognize that you had a mental injury. And the Supreme Court said, yes, we agree. Reviewing lower court decisions, that is exactly what our law has developed into. And that's true in my experience and in the experience of the practitioners I talked to in the preparation of this paper, of human rights law as well. You're now, as an applicant seeking access to human rights, being forced to fit yourself into a mold that a decision maker can recognize as objectively as a disability. And in fitting yourself into that mold, you're more and more being required to provide objective medical evidence that's authoritative and expert. And the problem, I think, practically speaking, is strategically, if I'm stepping into the shoes of someone who's trying to defend against a human rights claim, why wouldn't I be raising that preliminary objection every single time, right? It doesn't cost me anything as an employer, which is most often the opposing party when I'm doing cases. It doesn't cost me anything as an employer to say, yes, I understand, employee, that for the past 10 years we have recognized that you had a learning disability and we have accommodated it, but now that we're here today at a case, I don't believe it, show me. And if you're trying to access your rights, what can you do in that situation except expose yourself? You really aren't given much of a choice. While you may have day-to-day a privacy right, a theoretical right at least, to keep your confidential medical information confidential within a personal private sphere, once you're in that situation where you're being asked to prove that you in fact do have a disability, you're faced with a decision: either that privacy right is so important that I'm going to be prepared to risk losing my human rights application on the basis that I'm not a person with a disability, or I'm just going to give you everything. And so what I find with clients is that when faced with this choice, what they will do is they'll provide every single medical file they have going back to their childhood. They get forced to call their doctors to testify and be cross-examined by the employer on anything that is arguably relevant. They will have to go see a doctor chosen by the opposing party for an independent medical examination with someone who isn't their doctor, who's going to ask invasive medical questions that without any kind of clinical relationship or any kind of sense that what that person is asking about is in your best interest or even for a healthcare purpose. And they also have to, in a lot of cases, live with the knowledge that the other party might legitimately send a private investigator around to monitor their house and videotape them when they're going about their business to test the veracity of their claims. It is public stripping and not even clinical exposure in a very, very real sense. But you do it because you have no choice. Because it's better than the risk that you could lose and forego the human rights issue that brought you to the justice system in the first place. Because every time that issue comes up, there's a very real possibility that your evidence will be found to be insufficient, and you will be left without any right or recourse whatsoever. And what we've seen, I think, in the last couple of years, at least in the labor and employment context, is that, as I said at the outset, the problem begins to snowball. Because the more you give, the more it becomes expected that that kind of evidence will be shown in a hearing. And the more it becomes expected that that kind of evidence will be shown in a hearing, the more the refusal to provide it becomes your problem as the individual and not just the problem of the system, or the idea that that evidence maybe isn't necessary in this case, or maybe wasn't a reasonable request by the employer in the first place. And it also becomes a problem for medical conditions which are on the fringes of science, where we don't totally know how to diagnose these yet. Things like fibromyalgia or chronic pain. Things even like post-traumatic stress disorder a few years ago, which has only recently been added to the DSM. People in those kinds of situations trying to prove that they have a disability of those kinds are often in a difficult position where medical experts may not even agree that their condition exists. They may not have a solid diagnosis. They may not have identifiable concrete symptoms that can for sure be linked back to their condition. And yet, because this expectation of solid, conclusive, knee-high stacks of medical documents is now becoming increasingly the standard by which we measure whether or not you have sufficient evidence in human rights cases, these individuals are out of luck because the absence of that evidence is seen to be telling in some way. And we've seen this, especially in the employment and labor context, in a few cases recently, that the protections that have existed for individuals with disabilities to say you don't have to expose your entire medical history for the purposes of gaining access to human rights protections has been worn away. So for example, it used to be the case that all you needed to identify to an employer in order to gain access to accommodations for your disability in the workplace was the symptoms that actually needed to be accommodated. That used to be the rule. But it's not clear that that's the rule anymore. In 2012, a decision called Complex Services came out, which said if you've got a scary psychological illness and your employer might have some concerns genuinely that maybe you'll flip out in the workplace, you may be required justifiably by your employer to provide diagnosis, treatment plans, symptoms, prognosis, medication lists, all of these things. And if you don't provide them, they don't have to give you a job. And similarly, it used to be the case that if your employer asked you to attend a meeting with their doctor because they didn't like the information that your doctor was providing, you could say no. But in 2015, the Human Rights Tribunal of Ontario said, no, well, it's not that clear. There are going to be circumstances in which if we don't feel that your doctor is providing enough information, an employer can legitimately ask you to go to an independent medical examination, and if you refuse, they don't have to give you your job back. And I think what's scary about all of this, I think what's scary to me most about all of this is not a level of surveillance we've seen in human rights, at least in the preliminary, am I someone protected by the Human Rights Code sense, in the kinds of human rights protections that were discussed before disability really came to the forefront of the human rights conversation. You know, when you're talking about protection for religious beliefs, the standard is, do you have a reasonably held belief that's sincerely held, right? It's not, show me letters from your pastor saying that you attend church every week. But we are starting to see it in the rights that have come after disability. So you see it raised sometimes in trans rights cases. You see it raised in family status cases. And so it's not even just that the problem exists here in disability, that this conclusive proof of your identity as a person who is entitled to human rights protections is a problem. It's that it is becoming the standard for everything that the Human Rights Tribunal does. But to end on a positive note, that Sadati case, the one about mental injury and the standard that's needed in mental injury, while the Supreme Court noted that the lower courts had been dealing with this on the basis of an identifiable diagnosed psychiatric illness, identified and diagnosed by an expert, the Supreme Court did say in that case that that's not right. That's not the state of the law. It shouldn't be the state of the law. And that conflating mental injury with diagnosed, recognizable psychiatric illness that meets the DSM criteria shouldn't be how we go about this. That there are circumstances in which, as in the Sadati case, an individual can prove the existence of a mental injury which is compensable by calling their own evidence, calling the evidence of their friends and family who have noticed changes in them since the accident, because that was a tort case. That they do not have to provide medical evidence if they can provide compelling evidence which, on a balance of probabilities, because that's always been the standard, can demonstrate the existence of an illness even in the absence of a doctor. So I think, to wrap things up, the lesson for me as a practitioner is to not get complacent about what human rights tribunals expect from me, what labor arbitrators expect from me, to push back as much as possible without risking my client's best interests against these ideas that full disclosure of medical files is always going to be necessary and calling a doctor is always going to be necessary, and to start trying to make some room again for a social model perspective on the definition of disability. And for everyone who's not a practitioner, I think it's a similar message. It's just the idea that the social model is not fait accompli yet in Canadian human rights law, and that we need to remember that the medical model is alive and well in most people's conceptions of disability, and that the fight and the work around that issue still needs to be done, and now more than ever.